effect. Now, after you've had time to make an inventory of the assets and liabilities, you are required to notify the heirs and beneficiaries that there is a trust and that they have a right to challenge that instrument. You also want to meet with a group of advisors regarding distribution of trust assets and administration. And this would include your family financial advisors, such as Debbie Gross and Jim Johnson here at Lighthouse Financial Planning, a CPA, or a trust administration attorney. Now, many clients feel like they have to go directly back to the attorney who drafted the documents. In many cases, that attorney may have retired, so you can find a local competent attorney to advise you in these matters. Now, with the larger estates, where more complicated estate planning was needed after the death of the first or the second spouse, subtrusts may come into existence. And if that's the case, you'll need to apply for a tax ID number with the IRS for each of these additional trusts so you can open up bank accounts to hold those assets. Now again, there are critical dates that we want to keep in mind when we're going through a trust administration. Like I mentioned, we need to have the will filed within 30 days with the local county court. The final income tax return will be due April 15th of the year following the death of the trust maker. And then if a federal estate tax return is necessary, that will be filed 9 months after the death of the trust maker. Now, the final income tax return continues to be filed on the Form 1040, and it's only required if the trust maker actually had reportable income. Now, the federal estate tax return is completed on a Form 706, and the 706 does not have to be filed unless the trust maker's share of assets, including the retirement accounts and life insurance, exceeds what we call the exemption equivalent. And currently, the federal estate tax exemption is at $5.2 million, and as a result, very few of these 706s are being filed right now. However, unless President Obama and Congress act before year's end, beginning January 1, 2013, the exemption will fall to about $1.2 million. Now, if you have a home worth approximately $400,000 and maybe another $500,000 in retirement accounts, your estate will quickly exceed the $1 million exemption amount that we could be dealing with next year. And this is particularly the case if we have life insurance out there that will be paid upon the death or other accounts. Now, if the estate is subject to federal estate tax, it would need to be paid when you file the 706, 9 months after your loved one has passed. Now, while the vast majority of surviving spouses will have the opportunity to claim the unlimited marital deduction from federal estate tax, meaning that no estate tax will be due, that surviving spouse must still file the 706 if the spouse who's passed away, their share exceeds that exemption equivalent.
So just jumping in real quick, this would be a highlight of where, it seems to be a more complex situation, a little straightforward, in which it would be very worthwhile to seek the professional advice of somebody like yourself.
Yes, absolutely. Thank you, Debbie.
Yeah.
Now, just a quick review of some of the things that we want to make sure that we don't do. Now, if we have a trustee and maybe even a surviving spouse who's now the sole trustee, we don't want to do any distribution of assets without consulting the estate planning attorney, the financial planner, especially when we're talking about qualified plans, IRAs, where if we were to transfer, a retirement account to the beneficiaries, there would be substantial income tax liability, and we want to make sure we have the consultation of a professional before we do something of unintended consequences. And so that includes not liquidating or selling the assets without that proper tax planning. Now, in addition to tax planning, you also want to provide an accounting unless waived by the beneficiaries, and make every effort to have the beneficiaries sign a settlement agreement discharging potential claims against you as the trustee before making a distribution. You just want to protect yourself from liability. Now, if you were the trustee and you're also the sole beneficiary, you're only accounting to yourself, and there's no reason to be concerned. But if we have a more complex estate, we have a blended family with a number of beneficiaries, we want to make sure that the trustee is protected. So when the trustee provides that accounting, they should also provide notice that the beneficiaries have 120 days to present a challenge to the accounting in court. So I, as an estate planning attorney, I typically recommend my clients either wait out that 120 days or get a settlement agreement signed by the beneficiaries before they make